Welcome to In Camera, Hollywood Scandals, Legal Truths. I'm Adriana Collado, movie fan, history buff, criminal defense lawyer. Join me behind the scenes of Hollywood's most controversial criminal cases and uncover the hidden stories, excluded evidence, and legal tactics the public never saw. Let's go in camera.
September 5th, 1921, Labor Day weekend. Rooms 1219, 1220, and 1221 of the St. Francis Hotel in San Francisco. Bootleg liquor flows, music plays, people laugh. But by September 9th, a guest named Virginia Rapet would be dead, and Roscoe Fatty Arbuckle, Hollywood's highest paid actor, would be charged with her murder. This was the original Hollywood scandal, complete with public hysteria, moral outrage, and prosecutorial misconduct. But it was also a masterclass in criminal defense strategy, one that would take 3 trials and end with one of the most remarkable jury statements in U.S. legal history. To understand what happened in September 1921, you need to understand who Roscoe Arbuckle was and just how far he had to fall. Born in Kansas in 1887, Roscoe Conkling Arbuckle weighed more than 13 pounds at birth. He was teased mercilessly as a kid, and the name Fatty stuck. But by the 1910s, he had turned that liability into his greatest asset. Arbuckle became one of the world's biggest and highest paid silent film stars. He worked with Charlie Chaplin and Buster Keaton. He was a physical comedy pioneer, and audiences loved his jolly big guy persona. And in 1920, Paramount signed Arbuckle to a $3 million contract, the equivalent of about $40 million today. He was rich, beloved, and untouchable. Until he wasn't. On September 3rd, 1921, Arbuckle and 2 friends, Lowell Sherman and Fred Fishback, drove from Los Angeles to San Francisco for a Labor Day break. They checked into 3 adjoining rooms at the St. Francis Hotel. Now, despite sustaining second-degree burns on his butt from an onset accident, yes, really, Arbuckle was ready to celebrate. On the afternoon of September 5th, they threw a party. And among the partygoers were Virginia Rapet, a fashion designer, aspiring actress, and model, and Maud Delmont, a woman with more skeletons in her closet than a cemetery. What happened next? Depends who you asked. Here's what we know for sure. At some point during the party, Rapet was found in distress in room 1219. A hotel doctor was called, concluded Rapet was drunk, gave her morphine, and left. Rapet remained at the hotel suffering for 3 days before she was transferred to a hospital. Virginia Rapet died on September 9th. Official cause of death? A ruptured bladder and peritonitis. Maud Delmont couldn't run to the police fast enough with her version of what happened. According to Delmont, Arbuckle lured Rapet into his room and said, much like a cartoon villain, "I've waited for you 5 years and now I've got you." You can almost hear the laughter in the background. Delmont claimed she heard Rapet screaming and tried to enter the room, but the door was locked. When Arbuckle finally opened it, he was smiling and wearing Rapet's hat. Rapet was on the bed, writhing and crying, "He did this to me." Delmont told police that Arbuckle, at 260 pounds, had sexually assaulted Rapet and ruptured her bladder with his weight. Other witnesses told a different story. Some said Arbuckle had been trying to help Rapet after she became ill from drinking too much. Some said the door was never locked. And some said Rapet's cries had nothing to do with an assault. The press, of course, got wind of Delmont's allegations, and after that, everything else was just noise. As if Delmont's story wasn't juicy enough, the press got creative. At one point, the media circulated a claim that Arbuckle sexually assaulted Rapet with a piece of ice and a Coca-Cola bottle. Spoiler, that never happened. The medical evidence and autopsy showed no signs of sexual assault, no marks of violence, nothing consistent with an attack by a 260-pound man. Instead, the autopsy report stated specifically that the ruptured bladder appeared to be from natural causes. But hey, who needs facts when you've got a dead body and a celebrity suspect? The media had already convicted Arbuckle in print. Newspaper magnate William Randolph Hearst bragged that the Arbuckle scandal sold more newspapers than the sinking of the Lusitania. Theaters pulled Arbuckle's films, and church groups and women's organizations demanded justice. Enter San Francisco District Attorney Matthew Brady, a man with gubernatorial ambitions who saw his golden ticket. Brady rushed the case to a grand jury before all the evidence was even in, and the grand jury indicted Arbuckle for manslaughter. But that wasn't good enough. Brady upped the ante by seeking a first-degree murder charge, a death penalty case. Amidst the chaos, Arbuckle turned himself in on September 11th. He sat in custody for 3 weeks while the court sorted out his bail status. A preliminary hearing followed, and this is when a judge determines whether there's probable cause for a criminal charge and sets the defendant's bail status. Arbuckle's preliminary hearing was an omen of things to come. After reviewing the evidence, Judge Sylvain Lazarus said he found nothing to sustain the murder charge and, quote-unquote, barely enough to justify holding Arbuckle for murder. But then Judge Lazarus made the following statement, and I quote, "We are not trying Roscoe Arbuckle alone. We are not trying the screen celebrity who has given joy and pleasure to the entire world. We are actually, gentlemen, trying ourselves. We are trying our present-day morals, our present-day social conditions, our present-day looseness of thought and lack of social balance. I have decided to make a holding on the ground of manslaughter." So the judge essentially admitted on the record that he was holding Arbuckle not because the evidence justified it, but because the case had become a referendum on American morality. Had there been an appeal, that statement alone would have practically guaranteed a reversal. But it never got that far. Bail was set at $5,000, and Arbuckle got out. The question now was whether Arbuckle's defense team could undo the damage. Arbuckle assembled what the press called a $1 million defense. Now, the legal fees were not actually $1 million, more like $700,000, but it was money well spent because the defense uncovered evidence that never made the front pages. Arbuckle's lead counsel was Gavin McNabb, a California political powerhouse and Democratic kingmaker. Another attorney on Arbuckle's team was Milton Cohen, who had a very useful connection to Virginia Rapay. More on that in a moment. The defense's challenges were significant. Brady's theory that Arbuckle's assault caused the ruptured bladder had to be dismantled scientifically, not just legally. And public opinion had already convicted Arbuckle, and the prosecution's case, however thin, had a foundation, Maud Delmont's accusations. The defense strategy was methodical and multi-layered. Let's break it down. First, destroy Maud Delmont's credibility. The defense did a deep dive into Maud Delmont and uncovered an extensive criminal record for extortion, fraud, and blackmail. McNabb alleged that Delmont, operating under the alias Madam Black, procured young women for wealthy women's parties. Delmont and the women would then extort those men with rape accusations. A claim Delmont never denied because she was never called to testify. But the smoking gun was actually a set of telegrams. Arbuckle's lawyers discovered that on September 7th, 2 days before Rapay died, Delmont sent 2 incriminating telegrams. The message? "We have Roscoe Arbuckle in a hole here. Chance to make some money out of him." Seems that Maud Delmont was already planning the shakedown before Virginia Rapay was dead. McNabb raised this at the preliminary hearing. D.A. Brady's response? He conveniently never called Delmont to testify at any of the 3 trials. So the person whose allegations set this in motion never appeared on the stand. And Roscoe Arbuckle never got to confront or cross-examine his accuser, a flagrant violation of his constitutional rights. McNabb exploited this with a line that became one of the great courtroom burns of the trial. Delmont was called the complaining witness who never witnessed. Second, Attack the supposed fingerprint evidence. At the first trial, the prosecution had a forensic expert testify that Arbuckle had left incriminating fingerprints on the hotel room door, implying a struggle. McNabb punched back by calling a hotel maid who testified that she had cleaned the door before any forensic investigation took place, which would have contaminated or destroyed any prints. At the second trial, the prosecution's own forensic expert reversed himself, and the fingerprint evidence was effectively exposed as fabricated. I believe the legal term for this is cooked. Third, expose the DA's misconduct and abuse of power. During cross-examination, McNabb elicited some startling testimony from several prosecution witnesses that DA Brady had threatened and intimidated them into giving false testimony. One witness said that Brady had threatened to throw her in jail if she didn't testify against Arbuckle. Another recanted her testimony entirely, saying she had only been repeating what Maud Delmont told her to say. That witness ghosted and fled the country before the third trial even began. Defense, mic drop. Fourth, debunk the DA's theory about Rapé's cause of death. The defense called doctors who poked holes in the theory that Arbuckle's heft killed Rapé during a sexual assault. They did this by testifying about Rapé's pre-existing history of bladder problems and medical treatment. Even more impactful, McNabb got the prosecution's own medical experts to concede that the ruptured bladder could have been caused by a pre-existing condition. And if a 260-pound man had assaulted Rapé, the autopsy would have shown extensive bruising and trauma. It showed none. Fifth, throw Virginia Rapé under the bus. Now, this is a common legal tactic still used today. The problem? The architect of that strategy was attorney Milton Cohen, who before joining Arbuckle's team had been Virginia Rapé's personal lawyer. Cohen knew Rapé's history and personal information better than anyone and weaponized it at trial. But now, some context. In 1921, attorney-client confidentiality did not survive the client's death. So what Cohen did was not legally improper. Under modern rules, though, the duty of confidentiality survives death. So today, this is an absolute no-go. But at trial, the defense used Cohen's inside knowledge to argue that Rapé's partying and excessive drinking was consistent with her documented history, not with being assaulted. 6. Leverage what turned out to be the deciding factor, Arbuckle's testimony. At the first trial, Arbuckle took the stand. He was direct, specific, unflustered. He vibed with the jury, and 10 of the 12 voted to acquit. But the first trial still ended in a hung jury. One holdout, juror Helen Hubbard, had announced at the start of deliberations that she would vote guilty no matter what. She refused to review the evidence, look at exhibits, or even engage with the other jurors. After 44 hours of deadlock, the judge declared a mistrial. The critical fact then emerged. Hubbard's husband worked for the DA's office, which was cause for excluding Hubbard from the panel had either side caught this during jury selection. If so, Arbuckle's ordeal might have ended at that first trial. My guess is that Hubbard didn't disclose it, so neither side was aware of the conflict. For the second trial, McNabb was so confident in the evidence that he didn't put Arbuckle on the stand. The jury deadlocked again, but this time it was 9-3 for conviction, a complete reversal from the first trial. The conclusion? Arbuckle's absence from the stand made him look guilty. Now let's go sidebar for a moment. Every defendant has a Fifth Amendment right not to testify, and judges instruct juries that they cannot hold that silence against the defendant or treat it as evidence of guilt. But here's where law and human nature collide. Jurors sometimes disregard this and presume that a defendant who doesn't testify has something to hide. Arbuckle's second trial is a textbook example of why the decision to testify is one of the most consequential calls a defense attorney makes, and why it must be carefully considered at every trial, even the second time around, on the same facts. Lesson learned. For the third trial, McNabb took no chances. He put Arbuckle back on the stand, and in closing arguments, McNabb didn't simply argue reasonable doubt. He argued actual innocence. He emphasized the miscarriage of justice done to Arbuckle and invited the jury to feel outraged on his behalf. The jury deliberated for 5 minutes. They spent most of that time writing a statement. The verdict? Not guilty. But the jury went further. They affirmed Arbuckle's complete innocence, excoriated the prosecution, and issued a formal apology to Roscoe Arbuckle. Their statement read, "Acquittal is not enough for Roscoe Arbuckle. We feel that a great injustice has been done him. We wish him success and hope that the American people will take the judgment of 14 men and women that Roscoe Arbuckle is entirely innocent and free from blame." All 12 jurors and the 2 alternates signed that statement. Pretty extraordinary. After the trial, Matthew Brady never faced any professional fallout from the Arbuckle case. He remained San Francisco's district attorney for roughly 2 more decades and died in 1952. He never became governor. Maud Delmont also walked away unscathed. She faced no criminal charges. And in one of the more jaw-dropping footnotes to this already insane story, she went on tour, performing a one-woman show billed as the woman who signed the murder charge against Arbuckle, the most sensational act on the American stage. Tickets cost between 10 and 30 cents. As for Roscoe Arbuckle, despite the acquittal and the jury's statement, his career was destroyed. The film industry canceled him, caving to censorship threats and pressure from moral reformers. Paramount voided his $3 million contract, and he went bankrupt paying his legal ills. Roscoe Arbuckle kept his face off the screen, directing occasionally under a pseudonym, and with a bit of help from friends Chaplin and Keaton. Then in 1933, Warner Brothers finally offered him a contract to act again. On the night he signed it, Arbuckle celebrated with his third wife. He went home, went to sleep, and died of a heart attack. He was 46 years old. Roscoe Arbuckle's case remains a cautionary tale about the abuses of overzealous prosecution and the reality that you can win in the courtroom and still lose everything outside of it. It's also a reminder that a vigorous, well-prepared defense is the only thing standing between citizens and a system that can be corrupted by public opinion, abuse of power, and human nature. Thanks for joining me in camera. I'm Adriana Collado. Roll credits. We're adjourned.
Like what you saw? Hit subscribe and follow us on social media. And leave a comment below. I want to hear your take. There's always more to the story. I'll see you next time in camera.